much to ask?
No, that's not too much to ask, sir.
Sorry.
Okay, I didn't think so. Your pretrial court date will be June 16th in front of Judge Bryant. Do you have any questions regarding your bond and or court dates?
Could I get a copy of the court dates?
Mr. Reagan, your attorney will handle all that.
They should be able to give him a copy there.
Give him one there.
Thank
All
you.
right. Okay. Who's the walk-in?
Number 4.
Okay. All right. CJC, do you have Mr. Foster?
Do, Your Honor. He's coming right now.
Okay. All right, gentlemen at DDC, what's your name again?
Craig Beasley.
All right. All right, Mr. Beasley, you have some traffic matters in which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside these arrest warrants, give you a personal bond, and each of these misdemeanor matters that carries a maximum penalty up to 93 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be against you. You have the right to an attorney and afford attorney one way point on behalf. Tickets are you 655-502-223. Charging people $20 to park in a city-owned lot. Creative. You 656-557-23. Parking vehicles without license to operate. Parking lot without a license. Consistent here. Ticket U 695-86624. Something about an orange flag? I don't know. Temple State orange flag. Ticket P113091. Driving while license not valid. Driving on registered motor vehicle, no insurance misdemeanor. Ticket P113091. Driver license not valid. Driving on registered motor vehicle, no insurance misdemeanor. Ticket P1409-735. Park autos on city property. Like to park cars, apparently. Ticket P1535521. Again, parking autos on city property. Ticket P1535521. Parking autos on city property. Ticket P1550654. Parking autos on city property. Ticket P1550654. Parking autos on city property. Ticket P1649017. Parking autos on city property. And finally, ticket U66040623. Consuming Budweiser beer in plain view at the Q Line platform. So instead of parking cars, you're allegedly picking the Q Line. These misdemeanor matters, sir. You're getting a personal bond or dollar amount pre-trial June 16th in front of Judge Yancey. Now to your main matter, Mr. Beasley. Case number 24046204001. Piece of the Michigan versus Craig Beasley. Appearances, please.
Lisa Coyle, appearing on behalf of the people.
Your Honor, I'm breaking on behalf of Craig Beasley with waive the reading, stand mute. He's been advised of his rights, Your Honor.
All right, the court will enter not guilty plea on behalf of Mr. Beasley. Bond recommendation from the people.
This is a capious matter, Your Honor.
That is right. $1,000 10% capious bond for Judge Bryant.
Again,
sorry,
I see two failures to appear in a short time. I'm asking for that 1,010% or personal with the tether.
Mr. Reagan?
Judge, I would ask, respectfully for the 1,000 personal, Judge. My client, Judge, he went to the Zoom room. He called in, spoke with Judge Bryant. She said that she's going to give him info on the next court day, Judge. He zoomed back in 3 times, couldn't get in, called the court. Court didn't have any information, so he made every attempt. Sometimes things happen during Zoom, Judge, but it's a non-assaultive case. So I am asking respectfully, Judge, and it has some age to it too. But I am asking for a personal bond.
$1,000 personal bond. I'll give you the benefit of the doubt, Mr. Beasley. I'm more so concerned about your alleged history of false pretenses, charging people to park in a lot that you don't own. And apparently they're city-owned lots. I am much more concerned about that, taking people's hard-earned money. $1,000 personal bond. I think there's only been one capias, as I see it. Pre-trial June 13th in front of Judge Bryant. Mr. Beasley, step aside, please. Okay, is Mr. Foster ready?
Yes, Your Honor.
Okay, I left off. I did not give you your court dates. It was probable cause June 13th. And what was the dates? The other date, Mr. Reagan, and what judge?
June 18th. You never said the judge. It was June 13th and June 18th, Judge.
For who's the judge for Foster? Ms. Parham, what is the judge for Deontay Foster? No, the judge.
Oh, Taylor.
Judge Marlena Taylor for Mr. Foster. I think that concludes the matter now. For Deontay Foster, case number 250571778. Thank you, Mr. Foster. You have any questions regarding the bond and/or court dates?
You said a who?
I didn't say a who. I said a what.
You said my court dates?
June 13th, June 18th, both in front of Judge Taylor.
Oh, okay.
$100,000 personal bond.
Okay.
Thank you. Miriam Turner is, oh, hold on. Preston Clayton. Creighton, that's what it was. Preston. All right, Mr. Clayton was in person. Creighton, excuse me, station name for the record. It's case number 240-448-1101. Peace and Michigan versus Preston Creighton. Appearances, please.
Lisa Coyle appearing on behalf of the people.
Your Honor, Philip Reagan on behalf of Mr. Creighton, waiting for my reading. Stand
All right, the court will enter not guilty plea on behalf of Mr. Creighton. My recommendation for the people.
Recommending a $25,000 personal. This is a cross complaint. No contact with Miss Rakisha Edmonds. I do see a prior DV, but back from 2011 for him. So I would request the same bond as hers, $25,000 personal.
Oh, no objection, Judge.
All right, Mr. Creighton, $20,000 personal bond. His case is pending, not to possess any handguns, firearms, or dangerous weapons. No contact with Rakisha Edmonds. You cannot go back to the Kenmore address where this incident allegedly occurred.
Excuse me, sir.
That's his house. Hold on, Mr.
Has she moved out?
She been moved.
Yeah, I don't
I'm
think
talking to your attorney.
I don't think she's there. According to my note, Judge, she's not there any longer. But if she is there, obviously he can't be there. But I would just ask for no
Okay.
contact. Um, you know.
No contact. You cannot go back to the Kenmore address if Ms. Edmonds is there.
And Ms. Coy, you said this was a cross complaint. I just heard.
That's what my understanding is. It looks like she was arraigned on the 26th
Gotcha.
of May.
Okay, is that clear, sir? You cannot go back to the address if she's there. Okay. Pre-trial, June 13th in person in front of Judge Austin Garrett. Mr. Creighton, do you have any questions regarding the bond and or court dates? Have a seat, wait for your paperwork. All right, gentlemen of DDC, what's your name?
Andre Abel.
You said, what's your name now? Deontay Abram? All right, Mr. Abram, you have some traffic matters in which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside these arrest warrants. You approach the bond and each of these misdemeanor matters that carries a maximum penalty of up to 93 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. You can afford an attorney one-way point on your behalf. The tickets are P1018430. Driver license not valid. Ticket P1065440. Driver license not valid. Ticket P1080153. Driver license never required. No insurance misdemeanor. Ticket P1143645. Driver license suspended. No insurance misdemeanor. Supplying false information to an officer. Ticket P1229056. Driver license suspended. Ticket P1255564. Driver license never required. Ticket P1297010. Driver license suspended. Repeat offender. Ticket P1476842. No insurance misdemeanor. Driver license suspended. Repeat offender. Ticket P1615404. Driver license not valid. And ticket 412882. Driver's license in person. No insurance misdemeanor. In each of these misdemeanor matters, so you're going to press the bond or dollar amount. Pre-trial will be June 18th in courtroom 533 at 1:30 p.m. Is that clear, sir?
Sorry for not saying.
All right, now to your main matter, Mr. Abram. This is case number 250-564-6301, Houston, Michigan versus Dianetta Abram. Appearances, please.
Lisa Coyle, appear on behalf of the people.
Deliberating on behalf of Mr. Abram, Your Honor, waive the reading stand mute has been advised of his rights.
All right, the court will enter not guilty plea on behalf of your client. I have a $1,000 cash surety capious bond set by Judge Taylor. She does not want to hear this matter. That bond will continue. The court has no authority to change that bond. Bond redetermination will be Wednesday, June 4th, from the Chief Judge Mechanical. Public cause June 11th. Preliminary examination June 18th, both in front of Judge Taylor. What is that? All right, Mr. Abram, do you have any questions regarding your bond and or court dates? All right, step aside, please.
Jody Elam the third.
What's your name?
Okay.
Jody Elam the third.
Mr. Elam,
That's third.
good morning.
Good morning.
This is case number 250-574-1601. Houston, Michigan versus Jody Elam III. Appearances, please.
Lisa Coyle, appearing on behalf of the people.
Your Honor, deliberating on behalf of Mr. Elam would waive the formal reading stand mute. He's been advised of his rights.
All right, the court will enter not guilty plea on behalf of Mr. Elam. I want to put on the record what happened prior to calling Mr. Elam's case with respect to his capious bond. I note for the record that Judge Taylor set a $1,000 cash surety capious bond for Mr. Elam on May 23rd of this year. We called Judge Taylor's courtroom initially, and initially her direction was to continue the capious bond as set. Subsequent to that, but before we came on the record, Counsel Jessica Scheib indicated to the court that wanted to inform Judge Taylor that the reason Mr. Elam he walked in today and gave an explanation that he just plainly forgot the court date as to why he capious. We relayed that information to Judge Marlena Taylor. She gave me authority to hear the argument as to the capious bond. And that was relayed to both counsels prior to court. It's my understanding, and per my direction from the chief judge, Judge Taylor does not have authority to give me that authority. And we have been instructed that the only person that can change a capious bond is a judge, not a magistrate, and that the judge of record doesn't have authority to delegate me as a magistrate that authority. And it indicated that the reason why she gave me that authority, tacitly, I guess, with understanding, was that she was unable to log in. I don't have the authority. I don't think she has authority to give me that authority. The only person that can change that bond is if Judge Taylor comes on the record in my courtroom, which she's indicated she's not able to do, or if DDC logs into her courtroom to hear the bond. So with those reasons, I want to make a clear record of that I'm going to continue the $1,000 cash surety bond set by Judge Taylor. A bond redetermination will be June 4th in front of Chief Judge McConicle. Probable cause will be June 11th. Preliminary examination June 18th, both in front of Judge Taylor. In light of that, is there anything else, Mrs. Cole or Mr. Reggie, you want to put on the record?
I would, Judge. I know I'll let Ms. Coyle go first. She wants to put something.
Okay, well, I was just looking at my notes. There's a note in the file dated 5/22/25, which my understanding was the preliminary exam. It was set at 9:45. And someone wrote, defense counsel spoke to his client before, but hasn't heard from him in the last 2 weeks. Capious issued 1,000 cash surety at 10:40 a.m. Matter was set at 9:45. 5 days later, on the 27th of May, defendant appeared in person to turn self in on warrant, advised to go to first floor courtroom 134. So that's the only thing I can add to this.
Thank you, Ms. Cole. Mr. Reagan?
Yeah, Judge. So I appreciate the court, have much respect for the court. So I'm going to give you 3 reasons why I totally disagree with you, and I'd like for you to think and reconsider this. Those 3 things are Judge Austin Garrett, Judge Kenyatta Stanford Jones, and Judge Elanice Bryant. So when you say you don't have permission from a judge to change a bond, that's absolutely not true. You do, because they give you permission to. And it's not a rule that you can't, Judge. And I think Judge Taylor was very clear in saying, hey, listen, I can't hear it because I'm busy on my docket. I give you the authority to do it, just as Judge Garrett does, just as Judge Jones does, and just as Judge Bryant does. So it's no rule that says just because you're a magistrate, you can't change the judge's bond. If they tell you to, you can, Judge. And I think that's something that you can do. And I don't think it's a problem if you chose to do it. Now, if Ms. Coyle's here and I'm here, we can both argue it, and the judge says it's okay, I would think that it should be okay, Judge. I don't think that you are not permitted to do it. That would just be my thinking logically, Judge, from the way in which we handle other capious matters.
Okay, is that it? I thought there was 2 other points.
No, I mean, I just want to make that point, Judge. I said 3. Okay. I mean, those are 3 names, 3 judges that allow you to change the bond. So when you say that you don't have
and Mr. Reagan, you were absolutely correct. And there's a distinction between those cases. We have been given authority until further notice for misdemeanor matters. And the 3 judges you named all preside over misdemeanor cases. We clearly we don't have authority, given some previous confusion, which I don't want to put on the record, with respect to bonds being changed, capious bonds being changed at arraignment. And so you're absolutely correct. I do have that authority to notify otherwise for the change of any misdemeanor matters, but I clearly do not for felony matters, and so my decision stands.
Thank you, Judge.
Okay. All right, Mr. Elam, do you have any questions regarding your bond and or court dates?
Make sure I have a bond of $1,000.
Yes, sir. All right, step aside, sir. What's your name, sir?
Winston Wells.
All right, this is case number 250-453-9201. Peace of Michigan versus Winston Wells. Appearances, please.
Lisa Coyle appearing on behalf of the people.
For the record, on behalf of Mr. Winston Wells, Your Honor, waive the reading, stand mute. He's been advised of his rights.
All right, the court rendered not guilty plea on behalf of Mr. Wells. Bond recommendation from the people.
In this matter, the defendant is the biological father of the complainant in this matter, who is a minor. They allegedly did not live this just happened on the 25th of May. They were not residing together. The way the IR reads is that he body slammed her, causing her to urinate, break her toe, and sprained her wrist. There's also allegations that he was intoxicated at the time. For those reasons, Your Honor, the people do believe he is a danger to his daughter. I'm asking, I do not see any assaultive convictions. The only convictions I see are a 92 CCW and a 93 possession 25. So I'm asking for a 5,000 cash surety. I'm asking for an alcohol tether, and I'm asking for no contact with the complainant. Thank you.
Judge, we get a little
Hold on, Mr. Reagan. I got a question for you. Is there a court order custody arrangement?
I'm not sure. Do you have custody of Ms.
So we
McCroy?
have both personal and.
My understanding is I have court custody of Miguel McCroy.
I'm sorry, what now?
I believe, if I stand correct, I still have court custody of Brielle McCroy.
Is there a court order in place for that? From what judge?
It's a judge from Macomb County. I'm not familiar with her name. I forget her name, the judge's name.
How long has that court order been in effect?
It's been in effect since 2006, 2013, 14, or I want to say.
Okay, you don't remember. You don't remember the court date. You don't remember the judge.
I don't. It's in Macomb County, sir.
Okay. All right. Fair enough. Go ahead, Mr. Reagan, with your argument.
Story in terms of what the facts say, and Mr. Wells will say that he was simply trying to save, she was trying to jump out of a vehicle and he grabbed her so she didn't hurt herself. He wasn't trying to body slam, trying to do anything like that. It all started, the whole incident started because he was not going to drop her off over at her niece's house. Tried to jump out the car and he tried to grab her back in from doing so. He tells us his story. So, I'm listening to what he says. Obviously she has a story. So the courts are going to decide, whose story they believe, Judge. But right now, no contact. I don't know how that works. If he has a court order that he's got custody. I mean, obviously, we don't want contact if the court says no contact. But I will leave it to the court. I don't think a cash bond is necessary, Judge, when there are no convictions. Okay,
but Mr. Reagan, I got some follow-up questions. Are you saying that this is obviously you say this is a misunderstanding? I get that. But you're indicating that any alleged assault, assuming this assault or however you want to characterize it, he is presumed innocent until proven guilty, that this occurred in a moving vehicle?
That is
Yes.
my understanding, Judge. That is what my client informs me. You know, he was there. I wasn't there. So he tells me that that's how, you know, what happened.
So if I understand this correctly, that at an argument occurred in a moving vehicle and then later went to the patent address and then things furthered after that, I guess.
So, Judge, I mean, you, or what are you asking about the set of facts or the circumstances surrounding?
I just want some clarification. Yeah.
Judge,
And
it's an
okay, I
investigation.
know it'll be flushed. I know it'll be flushed out.
Right. And I'm just trying to say that no contact probably should be the provision. I don't want to get too much deep into it because I can tell you a story based on my client tells me. You can read something in that it may not be accurate.
Okay.
And so I don't.
All right.
I think that even though we're reading that, you know, I don't think this occurred in a car. She's saying that it may have began that way. She said that he slammed her onto the ground while she was on the ground. He picked her up and proceeded to pull her hair. He had picked her up for spending the holiday weekend with her. She does not reside with him. And that there was an argument, and whether it be whatever it may be about, this is obviously beyond the pale of any type of discipline, where we have a sprained wrist and a broken toe, and she's urinating on herself. Obviously, she was very panicked by, he's a grown man, and we don't know the size of her, but he's a male that's allegedly intoxicated at the time. And, you know, any man striking a woman, just the physical differences. So I do believe he poses a danger.
I don't want to open up a can of worms, but the reason why I go into the driving aspect of it is because there's allegations or representations that he had been drinking. And I'm trying to kind of compartmentalize.
I wasn't drinking.
Sorry?
Well, don't say anything. So, Judge, what Ms. Coyle just read out of that report, my client says is absolutely false.
Okay,
all of the
I got that.
Says is false. So he wasn't drunk. He was trying to save her from jumping out. She was incorrigible. She was upset. She wanted to go here. He was trying to say, no, you can't. And she tried to jump faster. That's his story. She has her story.
Okay.
That's just
all right. Mrs. Coyle, I want to thank you for kind of further clarifying the facts, as well as for you, Mr. Reagan. This is obviously two different versions that we flushed out at a later court date. It doesn't appear, unless, correct me, Mrs. Coyle, it does any history of violence or domestic violence between these two parties. Has there been a history of disciplinary issues here that you're aware of?
Not that I am aware of.
Okay. All right, Mr. Wells, I'm going to give you a $50,000 personal bond with the following conditions.